Okay, and good morning, everybody, and welcome to the Wednesday morning online seminar with Silver Shemmings-Ash. Today we are looking at extension of time and proving delay, presented by Conor, consultant solicitor with Silver Shemmings-Ash. Good morning, Conor.
Morning, Julie. Morning, everyone.
Good to see you all, and hopefully everyone's getting around the snow quite nicely. I know some people have got it worse than others. As always, we will be taking questions for Conor. In the bottom toolbar, there are the two tools, Q&A and chat. You can use either of those to submit questions, and Conor will do his best to answer as many as possible at the end. Again, as always, if there are any specific questions about specific projects or issues that you're having, please don't hesitate to drop an email directly to Conor. It's Conor Ahern at silverllp.com, and you'll see his contact details shortly. Okay, Conor, over to you without any further ado.
Great, thank you, Julie, and good morning, everyone. Yeah, look, as Julie said, we're going to be discussing extensions of time and also methods of proving delay also. Yeah, big topic. So we're going to get straight into it. That's a bit of my profile there. The agenda, so we're going to look at, what does the contract say? That's always a good starting point to understand what are the key terms that have been included in your contract. We're going to then look at some of the extension of time provisions and cover off some of the, I guess, common issues that we see arising in relation to, well, I believe I'm entitled to an extension of time, and what should I do now? And finally, we look at the methods of proving delay. Mainly based upon the Society Construction Law Delay and Disruption Protocol, and basically just set out, I guess, give an overview on each method before discussing some of the pros and cons associated with each one. Okay, great. Well, look, section 1. So we're going to look at the contract as a starting point. So essential terms, so what essential terms do I need in my contract that relate to time? So basically, if you summarize them quite succinctly, your contract should include a finish date, a mechanism for extending the end date, which are your extension of time provisions, which relate to particularly notice and your particulars. And then it must also be clear what are the consequences for a breach. So what am I liable for in the event that I'm late performing the contract? And that's generally a brief conversation around liquidated or unliquidated damages. I see a recent trend here. That really does relate to JCT contracts. Obviously, NEC contracts do include a program in their contract, but generally, the trend in recent years under JCT contracts has been just to include the start and finish date. I believe, in the past, employers were worried that having a contract, having a program included in the contract would, I guess, provide some grounds for the traditional delay and disruption type claims, as in it was very clear what the contractor intended to do, and then it's basically showing cause and effect related to some delay events that occurred throughout the project. So the trend is now is not to include a program in the contract. But then obviously, most contracts do include an obligation on the contractor to provide a program, usually showing a critical path and analysis pretty soon after the project has started. And that is basically meant to be included as a management tool in relation to time throughout the course of the project. So it's a baseline to understand, where do you sit in relation to progress as it stands. And basically just showing whether you're going to be on time or not. Okay, so now what happens if there is no finish date stipulated in the contract? Well, the position there is that there is an obligation to complete within a reasonable time. That's similar. That's under common law and statute, and under Section 14 of the Sale of Goods and Services Act 1982. It's a common law principle, and case law confirms the following. Some cases on this are Hick versus Raymond and Reeves. Now, this is back in 1893, and in that case, the contractor had fulfilled its obligation to complete within a reasonable time, even where there was a delay, so long as such delay is attributable to causes beyond its control and it acted neither negligently nor unreasonably. A more recent update was in the case of Shawton Engineering Limited versus DGP International Limited, where it was decided that reasonableness was to be determined at the time when the question arises in light of all relevant circumstances. So basically, I guess the message to be inferred from that is it's a generous position for the contractor where there is no end date included in the contract. So basically, the word of warning is make sure there is a completion date in there. Otherwise, the contractor will be, if he is in a position where he's complete within a reasonable time, that generally will not be acceptable to the employer. Okay, so the requirement to proceed regularly and diligently. Now, there is a clause, like most standard forms, again, now include an express term where the contractor is to proceed regularly and diligently. This typically gets discussed around termination, because basically the employer is alleging that the contractor has failed in his duty to proceed regularly and diligently. But really, what does it mean? So in the case of Sabit UK Petrochemicals versus Punge Lloyd Limited, the parties' contract required the contractor to proceed with due diligence and complete the engineering works in accordance with the contract. Now, the court concluded that due diligence meant carrying out the works industriously, assiduously, effectively, and expeditiously. So plenty of adjectives there in relation to, what that actually means, but it basically means, progressing, in a very industrious manner and doing your best to progress the works. There's so much discussion around this termination type disagreements that it always bears out in the facts in relation to what actually in fact occurred. Now, can the requirement to proceed regularly and diligently be implied? And this is decided in the case of Leander Construction Limited versus Mullally & Co Limited, where the court confirmed their reluctance to imply a duty to proceed regularly and diligently. And what the court said in that case is that if you want your contractor to proceed regularly and diligently, well, then that must be clear in the contract. Don't try to rely on an implied term to use that against the contractor during the course of the project. So again, making sure that there is a requirement on the contractor to proceed regularly and diligently is a very useful starting point for any employer. Okay, is time of the essence. Now, time of the essence was, very common in the past. Now, what it means is that time being of the essence is a contractual provision, and not is a condition. So it's not a warranty or an innominate term. So basically, it's central. It goes to the root of the contract. Time may be of the essence where the parties have expressly agreed the time frame is strict. The subject matter of the contract considers time to be of the essence, or there is unreasonable delay and one party has served the notice on the other, making time of the essence, which was the case in Ricards versus Oppenheim back in 1950. And that related to the late delivery of the chassis of a car. Basically, where the client said, can you fix my car? I suppose the garage said, yes, we can fix it. There was a delay. He issued a notice to say we need it fixed immediately and time is now of the essence. Still was late delivered, and basically he terminated the contract as a result. Now, time of the essence, it will depend on the facts. I mean, arguably at the moment, given the pandemic, the construction of hospitals, arguably time is of the essence there, but it won't be implied. It will have to be discussed and agreed between the parties, but do watch out for it, as it may happen on one of your own contracts, and if you're unsure about what it means. Okay, so moving on to section 2. So section 2, we're going to look at extension of time. We're going to look at what are the extension of time provisions, but starting out, what is the advantage of having extension of time provisions included in your contract? Well, basically, the extension of time provisions benefit both parties. It benefits the employer as it reserves the employer's right to deduct liquidated damages in the event that the contractor is late. It benefits the contractor as they are relieved of liquidated damages if the delays are for risks which belong to the employer. but they can also claim additional costs associated with delays if the delays are included as relevant matters for which the client or the contractor may be entitled to additional loss and expense. So there's two, that's the benefit for the contractor. And really, it's actually also a benefit to the contract, because if you have extension of time provisions, neither party will be in breach of contract in the event that either one of the parties causes delay. Now that's the real benefit, and we'll see why now. Because why do we need a mechanism to extend time? Absent an extension of time clause, an act of prevention by an employer releases the contractor from its obligation to complete the works by a fixed date. The contractor's time obligation is then considered to be at large, and the original obligation to complete the works by a fixed date is replaced by an obligation to complete within a reasonable time. Now we discussed reasonable time, and I guess it's it's a generous position for the contractor to be in. So the employer will want to do everything in its power to ensure that time does not become at large. The best way to do this is where it's got suitable clauses that deal with pretty much any foreseeable delay event that may be caused within the contract. And these kind of time at large claims were common prior to the development of standard form contracts. Before the development of the standard forms, events used to occur which neither party knew what the position was or how they were to obtain an extension of time. In such cases, then frequently it happened that time became at large. But recently, as the standard forms have developed, and the courts are now reluctant to find time at large when the contract provisions cater for delay, as per the recent case of Severfield UK versus Jura Folguera. And that's basically the court saying that they're not going to interfere where there are extension of time provisions, regardless of how difficult it may be to understand what the extension of time in fact is. That doesn't mean, even though it might be difficult, it doesn't mean it's impossible, or it doesn't mean that any of the events that have occurred cannot be worked out to, in fact, calculate what the new completion date ought to be. So basically, it's like, it's a word of warning to any contractors who seek to argue that time is at large because of the generous position it is for a contractor. You need to have a good case. You need to really analyze the extension of time provisions and basically check to see that it's not catered for within those, because if it is, any allegation that time is now at large by a contractor is pretty much doomed to fail. Okay, looking at the express wording in the contract. Now, so this is the clauses here typically relate to the type of language included in the JCT contracts. Now, this clause is what I call a catch-all clause for a contractor. It's a nice one to have for a contractor. And what it says is that any impediment, prevention, or default, whether by act or omission by the employer, the architect or contract administrator, the quantity surveyor, or any employer's person, except to the extent caused or contributed to by any default, whether by act or omission of the contractor or any contractor's person. Now, I say that's almost like it's a catch-all clause because it's the one that gets cited most frequently in my experience, and it mainly relates to any impediment, prevention, or default by the employer's person. Now that includes the employer's architect, the the structural engineer, the contract administrator, even perhaps, where they have failed to carry out any action, and by any action I mean basically failed to issue design information or any other information needed in order for the contractor to carry out the work. And you can see that why this is a catch-all, because it can cater for so many different circumstances for that in effect it works. It works in favor of the contract to ensure that whatever happens, a new overall completion date can be calculated, hence preventing the time at large type arguments. Now, there are also neutral events. So neutral events, I've listed some here which which are occurring almost as we speak. So force majeure. Now most people understand force majeure to relate to COVID-19 and the ongoing pandemic. Now that hasn't actually been tested as of yet, but it's basically been it's seen as a clause which can cater for COVID-19 and its effects on program since the pandemic started almost 12 months ago now. And that is the basis upon which most contractors have applied for their extensions of time in relation to COVID. We also have exceptionally adverse weather, including snow and ice, which if a lot of you are in the UK, but there's a lot of people online who are overseas. We have a lot of snow and ice in the UK at the moment. And exceptionally adverse weather is it's a delay event. It's under a JCT contract. It is a relevant event. Now, how do you prove that? Well, I think the NEC4 suggests one approach where you look at a 1 in 10 year event as a delay event. So you'd want to look at corresponding weather records for the previous 10 years to understand, how free, did we get snow? Did we get ice? How long was the temperature below freezing for, etc. You need some analysis around that to show that the current snow and ice is in fact exceptionally adverse weather, and you have suffered the delay as a result. Finally, I include statutory undertakers. Again, this is an event which is pretty much beyond the the control of either party. This used to happen frequently when I was working as a quantity surveyor, when we were basically digging basements here in London. Mainly cables running through the site was the most frequent type of delay from a statutory undertaker. And in such events, it was reasonable for the contractor to be entitled to a delay as a result, obviously on the basis that the standard form had included for such in the relevant events section. But what you'll notice about the main difference between the catch-all clause and the neutral events, the catch-all clause, if most of you are familiar with the JCT contracts, is that follows through into the relevant matters for which you'll be entitled to loss and expense for also. The same can't be said of the neutral events. Force majeure, COVID, exceptionally adverse weather, statutory undertakers, etc. They generally they're not included as relevant matters. Now you can amend that in your contract, and obviously you need to check the contract to see if it's a basis for loss and expense. But that is the key distinction between what we're discussing here. I thought it was an important point because there has been some, from the pre-submitted questions, there has been, I guess, a lot of the questions relate to how does it translate into loss and expense. Now, do bear in mind that, if you look at your standard form contract, you'll typically have about 15 or 16 grounds for a relevant event, but you'll only have about 5 or 6 for a loss and expense type submission. So do bear that in mind. We'll probably discuss that more in the questions to follow at the end, but I just want to make that clear to people. It's a very important point to bear in mind, and please don't get extensions of time or relevant events confused with loss and expense. They can be the same ground. For example, the catch-all clause, but it's not always the case. So don't always assume that to be the position. Okay, so condition precedent to provide notice. This is one that's discussed at great length also. So the requirement for serving of notices is usually only directory and not mandatory. And what I mean by that is the contract usually requires the notice, but in the standard form JCT, it's not mandatory. You can if you submit your loss and expense, I mean that in itself can be taken as a notice. So it's there basically for guidance. The requirements for condition precedent under English law were established in Bramer Handelschaft versus Vanden Avenue is a gem, and basically requires that precise and clear timetables must be identifiable, and the result of missing the timetable must be clearly spelled out. Now that was a position back in 1978, and basically The courts are reluctant to interfere with clearly drafted condition precedent clauses if the requirements set out in the notice provisions are clear. The contractor must ensure that they comply with any procedural requirements in the contract regarding the form, content, and timing of the notice. Generally, the main one to watch out for there is the timing, because even though the JCT language is, within a reasonable time, or as soon as you become aware, that generally does get amended to say within a specific time period, which is generally either 14 days, 21 days, 28 days. And that's really important, because if you fail to give the notice, then you're going to struggle to get your extension of time requirement off the ground. So do bear that in mind. Very important. If you do have a timing requirement in the contract, like you do in all in NEC contracts, you must get the notice in on time. Now, a recent case is Steria versus Sigma Wireless Communications, where the court decided that notice requirements and extension of time mechanisms do not need to contain a warning that failure to comply with the clause will result in the contractor losing its entitlement to an extension of time. So what he's saying is that if you have a requirement to submit your notice for an extension of time within a certain time frame, it doesn't need to be spelled out what the consequences are. Really, it pretty much speaks for itself what the consequence will be. Now, can the requirement for notices be waived? The employer is free to suspend or waive the notice requirements under the contract if they so wish. It could also be waived by silence or conduct, as per City Inn Limited versus Shepherd Construction Limited, where both parties effectively ignored the notice requirement and proceeded to grant an extension of time. Just on that, that was, that's an area that is always causes a good bit of conversation early in a project, because if you're a contractor and you have a requirement to provide notice, it can prompt some difficult discussions up front, which may not be the ideal way to start a relationship with your client. So discussion should be had early. I mean, I used to have these conversations as well, because you want to get the notices in, especially if that's what the parties have agreed in their contract and you're effectively required to administer that. Then you must submit the notices. Some employers can be, they mightn't like to get letters or emails relating to delay, but if that's what the contract says, then that's what you really ought to do. And in order, it just creates dialogue. And if the employer decides to waive them afterwards, then well and good. But I think as a contractor, you should be getting your notices in, almost regardless of the response from the employer. I think meetings are sensible then to discuss the content and the need for such notices. But I mean, if your contractor is required to give his notice, then that is what you should do. Regardless almost of the response from the employer. Okay, so what happens if the employer rejects or does not deal with the extension of time? So either he rejects it and he basically says the contractor has no entitlement, or he's failed to consider the extension of time within the period described in the contract. In NEC, if the employer fails or the project manager fails to deal with the application, then it's taken as it's been agreed. The same can be said in JCT. It doesn't say that. And generally, if this has happened in the case of PBS and Ergo versus Bester, and basically where the employer fails to deal with the extension of time requests within 12 weeks, then there's two options available to the contractor effectively. The contractor can refer the issue to adjudication, basically on the basis that a dispute has crystallized, insofar as there is now effectively a disagreement between what the entitlement to an extension of time in fact is, or also can potentially end up in a termination dispute. Now, that case, PBS and Ergo, was centered around the termination dispute, and that's in fact what happened. But I think you'd be a brave contractor to be alleging termination on the basis that failure to the employers failed to deal with the extension of time application. So again, it's just one to be aware of, what does the contract require you to say? If you're NEC, it's clear, JCT not so clear, but you have options and you always need to consider, whether the, I guess, whether you want to go to adjudication, whether it's a dispute. That's, based on the facts and based on how reasonable the employer has been in his assessment, you can take further steps as necessary. Okay, so finally in this section, we're going to look at the consequences for failing to complete on time. So as we all know, very common in our construction contracts is that failure to complete on time, the employer is going to deduct damages from the contractor. That's not too controversial. Whether such amounts are liquidated or unliquidated depends on the wording in the contract. Liquidated obviously means that the parties have, pre-agreed a figure, and under the old kind of liquidated damages wording based on Dunlop and Selfridge back in, I think it was 1915. It was a genuine pre-estimate of the employer's loss as a result of delayed completion. There can also be unliquidated amounts, and if the amounts are unliquidated, then you're within the realm of general damages. Now, if unliquidated, the employer has to prove the loss. It takes, it's a lot, it's more difficult procedure to administer. But from the employer's point of view, we can potentially be entitled to even greater amounts than those that have been previously liquidated or that previously agreed as liquidated with the contractor. So again, it just comes down to the relevant wording of your contract. It can also be grounds for termination because this happens in the case where the contractor is so far behind in his program that it's grounds for termination under your contract, and that's in fact what the employer will want to do in order to employ another contractor in order to complete the works as quickly as possible. So they're generally the two consequences for failure to complete on time. Right, so we're going to move on to this proving delay. So in this section, we're looking at, what are the questions that need to be answered? So basically, when you're looking at proving delay, we're considering, we're asking the questions, I guess, what was supposed to happen, what did actually happen, what were the variances or the changes, and how did it affect the project schedule? Because events have to have happened that that have delayed the project, and what we're trying to do is to establish those as being risks for which the employer is responsible for under the contract. So for the contractor to establish an entitlement to his extension time, so there's entitlement. So that's basically citing the relevant clause, the relevant event that has occurred, to say that this is a relevant event under the contract, and it is for which the employer is responsible. For example, as I mentioned earlier, force majeure event typically at the moment centers around COVID-19, but you also have the other, the Employers Act of Prevention, as we discussed earlier, the catch-all clause. You've also got the variations. Variations are usually the number one cause for extensions of time because, as we know, construction projects, do vary during the course. So it's it's only right that the employer is that the contractor is entitled to additional time in which to carry out the variations also. Third point is the contractor must then prove the effect of the relevant event and isolate these effects from other potential factors impacting the works. So what this means is he must prove the effects. He must show that that the event, so for example, COVID-19 has affected the progress of the works. And after he's shown that that's a risk for which the employer is responsible under the contract, he must carry out an analysis of what that effect has in fact been, and isolate that effect from other potential factors. So isolate it from other potential factors, such as other relevant events and other delays, such as perhaps contractor delays also. So it must be clear, what is the relevant event which the contractor is actually applying for. The contractor must demonstrate mitigation measures to prevent delay and satisfy his obligation to constantly use best endeavours to prevent delay in the progress of the works, however caused, and to prevent their completion being delayed or further delayed beyond a relevant period for completion. And that's a standard JCT requirement. Mitigation is only required to the extent that it reasonably saves costs and prevent delay. Depends on the mitigation measures required. I mean, best endeavours can arguably require the contractor to incur costs which may perhaps not be recoverable from the employer. So it's very important to check the wording on the mitigation measures, but do bear in mind that there is always a duty on the contractor to mitigate the potential delay caused to a project. That's an ongoing mitigation. That's an ongoing requirement for any contractor, and one that always must be borne in mind by a contractor, is that you do need to take all reasonable steps to, in fact, to try and mitigate and reduce the delay as much as possible. Finally, the contractor must be able to produce evidence to substantiate the truth of its submissions concerning the cause of the delaying event and its effects. So here we're into records. What records does the contractor have to be able to show the relevant event and its effect on the works, and also how that ties into a form of delay analysis, which we're going to come on to now. It's very important. It's cause and effect. It's it's showing what has happened and showing its effect, and underpinning the delay analysis by good records. Very important. A common problem with particulars submitted to a contract administrator in support of a claim under the contract for an extension of time and in potential subsequent adjudication also is a contractor's failure to present all the relevant facts substantiated by evidence. The main reason is because that's not an easy task. It can be it's quite involved, but I guess the more input that you make, the better the chance you have of getting a more favorable result. So that's just it. I mean, you got to work hard to get, to prove these grounds and to prove entitlement. If you do that, then you obviously stand a much better chance of recovering your extensions of time. Okay, so now we're into the methods of delay analysis, and we're looking at the 6 methods. These are as per the Society Construction Law Delay and Disruption Protocol. They're like the 6 most common methods used in industry. There are other methods, but these are the 6 that we're going to focus on for today. So you've got impacted as planned analysis, time impact analysis, time slice windows, as planned versus as built windows, retrospective longest path, and the collapsed as built analysis. So we're going to get into looking at these now. Okay, so the impacted as planned analysis. So an overview of this method is that it measures the impact of the delays on the contractor's as planned CPM network, the program matrix network. Various delays are formulated as activities and added to the as planned network in a chronological order, which show the effect of each delay. Dates between the networks before and after the impacts. So basically, it's where you have an as planned program and you impact that based on delays that have occurred. And what that should do, when you reschedule the program, is it should calculate out the revised overall completion date. Now, basically, the pros to this method are that it's relatively simple and inexpensive, because you have the as planned program. So you have the baseline program, and you're basically introducing the delay events to what that will do is just push out all of the remaining durations that were allowed for in the baseline program. So it's a relatively simple and inexpensive method of analysis, and it's very popular for prospective analysis, where basically the easiest way to think of an impacted as planned program is where the job has been late commencing for whatever reason, usual party wall awards, other contractor delays, whatever. So basically what it does is you insert a bar to show the extent of the delay up front. And what that will do is when you reschedule the program, it will calculate out the revised completion date. Very straightforward, and it's that simple method of analysis that is very useful when you're actually prospectively analyzing what the delay will be, or what the impact of the delay will be. Now, there are some cons associated with this method, and these include it uses a fixed as plan network to analyze out of context and time. The original baseline may be incorrect or not realistic to base the whole analysis on. It may fail to consider all the delaying events, and disputes as to the adequacy of the as planned. I mean, that's the real problem. I mean, this is good for prospective analysis, but not so much on a retrospective analysis, because it's not taking it. The big criticism is that it doesn't critique, or it doesn't. How can you show that the baseline in fact was reasonable? I mean, it's a very subjective type of argument to be having, to show that all of each and every bar that you allowed for in your as planned program was reasonable. You can see the difficulty that you will encounter with it. But look, it's there. It's mainly used for perspective to calculate the new overall completion date. Yeah, I mean, not so much. So I wouldn't be relying on it so much on a retrospective analysis. It's really not suitable for any form of retrospective analysis. Okay, time impact analysis. So overview of this is it introduces delay events again into the baseline program, and it uses contemporaneous programs to anticipate the overall delay. So what this does is it's prospective looking, and it basically uses contemporaneous programs. Now, that's basically either revised programs issued by the contractor during the course of the works, or drop-line programs as well that are provided in monthly reports, which are which is a common method of program management on construction in most contracts. Pros to this method are it can be updated contemporaneously based on the actual progress, and it can accurately predict the revised overall completion date also. And because it's constantly pushing out, or perhaps if the program has reduced, which doesn't happen that often but can happen, it accurately tracks that also. So I mean, it's really contemporaneous. It really is projecting the new completion date based on those drop-line programs. The cons to this is that, again, you need to verify the baseline information to show the durations were reasonable, realistic, and achievable with proper logic links. And it does not factor in mitigation or acceleration measures. Because what it does is because it's looking ahead, it's prospective. It doesn't anticipate future mitigation or acceleration. Because it could be the case that some of the bars, some of the durations later on in the project could perhaps have more time than what's required. So again, when you're looking ahead, unless you've gone ahead and actually looked into those individual events, it won't take into account any future mitigation or acceleration that may be possible. Again, so it really is only suitable for a prospective analysis, and not so much on the retrospective. Okay, next up is the time slice windows analysis. So an overview of this is that it requires contemporaneous programs throughout the project. The time slices are reviewed regularly, which is usually monthly, and this reveals the actual critical path based on the monthly progress. So again, it's it's very important. Again, I mean, I hope it's becoming clear, the usefulness of drop-line programs and contemporaneous programs. Very useful to understand. This is the reason why they are used as a program management tool to understand, where the project is at any given time. But what this does is it, effectively takes a time slice, and usually that's done monthly. Again, based on the delay. It also reveals it looks at the critical path also. And what I mean by that is it looks backwards as well. It can look backwards as well as forwards, and it can show where you might have had a critical path baseline program. What this can do is it can show the changing of the critical path, because often, you know, on complex construction projects, you could end up where you could have 2 or 3 critical paths. You might have only had one to begin with, but effectively, if events that were essentially floating in the original contract become critically delayed, then anything that floats can become critical if it's delayed for long enough. And that's the real benefit of the time slice windows, is that it can track the critical path almost in real time, so it can show you know, changes in the critical path, which is very important, because obviously when you're looking for an extension of time, we are talking about you know, critical delays on the critical path. I mean, you know, non-critical delays, yeah, you know, they're also important, but especially in the delay analysis, you want to be focusing on those delays to the critical path, really, because that's what's going to get you to your extension of time requirement. So pros of this method are that an accurate analysis based on solid records, again, the monthly progress reports, the drop-down program is very good, can provide a robust position which is difficult to undermine, and it can divide a complicated program into a coherent structure, because that's what the windows do, is that it analyzes a specific period within the overall program, which can be, you know, break a project down into, you know, into more into an easier to follow program, which is always a good place to be if it's easier to follow. Some cons of this is that it requires accurate records. The analyst must prove the baseline durations were achievable. Yeah, that's not as important as what it was in the previous slides. But also, this method is actually time consuming and costly. It does require a lot of input, but then again, you know, you get rewarded for that input, and you shouldn't have any concerns over, you know, whether in fact you're entitled to your extension of time or not. So, you know, again, it's horses for courses here. It's if it's worth doing, it's got to be done effectively. So yeah, the windows analysis, very good method of analysis. So the as planned versus the as built windows analysis. So this is usually used where there is a concern over the baseline program. What it does is it breaks the duration again into windows, which are then analyzed using records. It takes a common sense and practical approach to the delays. Yeah, so it effectively, it's looking at your as built, and it's basically honing in on the areas where you know where you feel you have been delayed, where you think that, yes, I was late getting information at such a point, and it became critical here. Carry out your windows analysis then to basically focus in on all the events that occurred at that time. As I said, it's a common sense and practical approach. It's focused on actual events. So, and that should always be underpinned by, you know, good records, emails, progress reports, site diaries, all that other correspondence that goes between employer and contractor, and basically, you know, focus in on, it really hones in on, you know, when the event occurred, when the delay occurred, and focus in on all of the steps involved. It can get into a lot of analysis on these windows as well. The pros is that it can be an accurate assessment, obviously, because it's based on actual records. It's, you know, there's a lot of common sense, practical approach involved. Now, I say that before I go on to the cons, because there's more input from the analysis rather than the software, which can be manipulated. Because obviously the party requesting the extension of time, it's more subjective in relation to how the critical path can be shown. And effectively, if you're looking to challenge it as an employer, you got to really hone in on the links to show the successor and predecessor events, because you may find that some of the links can become distorted or perhaps manipulated even to an extent. So it's got to stand up to scrutiny, especially if you're the party submitting. Also, it requires good records to be effective. I mean, look, that's kind of that's similar, especially on the windows. You really need good records, because again, it underpins what you're asking for, and it's reflective of actual events. So yeah, good records. It needs really good records to be able to justify. Okay, so the next one is the retrospective longest path analysis. Now, an overview here is that you have a detailed as-built program required for review. So that's where you have, been updating an as-built program best done, as most people know, during the course of a project, as it can be very difficult to do retrospectively at the end. It traces the longest path backwards from the end to determine the as-built critical path. Now, basically, it compares the key dates between the as-built and the planned program. So basically, retrospective longest path is really done if at the very end, if you end up in a situation where you achieve practical completion, but for some reason you've been late. You need a detailed as-built to be able to do this. Look, as I said, in the prose section, it can be an accurate assessment. I mean, it's based on actual events. It is best done if the as-built is carried out during the course of the project, because that way then it will be more accurate than trying to do all of this retrospectively. The cons of this is that it can be difficult to track and allow for changes in the critical path, and also that again it requires good records to be effective. That keeps coming up because records and extension of time claims are so important, which we'll come on to again shortly. But it can be difficult to track and allow for changes. I mean, obviously as well, doing the as-builts, as I've mentioned already, is that if that has to be done retrospectively at the end, very laborious task, very difficult to do. And again, importance of records, so important to have all of your information available to even consider going down this route in the event that you need to prove your delay. Okay, finally, the collapsed as-built analysis. So an overview of this is a form of as-planned but-for analysis, but this does not use the as-planned as a baseline, but uses the as-built schedule. So the as-built but-for. This is the as-built, and basically, but-for the delays caused by the relevant events for which the employer is responsible, I would have completed the works on an earlier date, but because of the delays, the project has been delayed. It involves removing delays of each party from the as-built so that the resulting schedule will give the completion date of the project, but for the delays of either party. And that's what we mean. What you want to do in the collapsed as-built is you want to show each of the delay events in their own separate bar. And basically that would build up to the actual as-built for the project. And then to collapse the as-built, what you do is you basically reduce each of the delay event bars back to 0. And when you reschedule that program, that's what should tell you when you would have achieved practical completion, but for the relevant events, delay events. So the pros of this analysis is that it's based on actual events and thus gives more credibility. Again, important that you got your records available to do this type of analysis. Cons are, once collapsed, is that it's forced to insert after the event logic links. Yeah, that is important, because after the event logic links, again, they're subject to there's a certain requirement, or they're quite subjective, and you got to watch that, especially if you're trying to defend an extension of time proposal that has been that has a lot of after the event logic links. You got to should really focus in on them if you're looking to defend. Delays being removed could result in an unrealistic network, especially when the delays are integral. It ignores circumstances and the dynamic nature of the critical path, and the input information is highly subjective. So yeah, you can see, it is a good method of analysis, but I mean, there is subjectivity required, and there's a great deal of subjectivity in even building up the as-built. But again, because it's based on actual events, it does give credibility. Again, all about the records, so important when you're considering the collapsed as-built type of analysis. Okay, so I guess the question that everybody has, so which is the correct technique? And the answer is, typical solicitor answer is that there's no straightforward answer, as each principle relies on the information available and the intended budget. And that's not a cop-out. That's reality. I mean, it is only as good as the information that's available to build up to assess what is the best method of analysis to proceed with. The techniques are employed have been a source of contention because they yield different results. I mean, you can use different methods, and different results will depend on whatever different method of analysis you decide to use. Final point is that the available records, again, are key to deciding what is the correct method. That's really the most important point. Note the techniques are employed have been a source of contention because they can yield different results. This was discussed in the case of Balfour Beatty versus the London Borough of Lambeth. Again, the adjudicator's decision challenged as the technique was not afforded commentary by the respondent, and the respondent's position was upheld in that. So basically, Balfour Beatty submitted programs. The adjudicator decided that there was deficiencies in those programs and sought to carry out its own delay analysis. It never saw a commentary from either of the parties, and therefore, breach of natural justice. The respondent's position was upheld. So, but just show, I mean, on looking at the same project, how two different methods. Balfour Beatty submitted one method thinking it was right, and then the adjudicator goes away and carries out another assessment, coming up with a different answer. Again, it just shows that there are so many techniques and ways of looking at the delay that even adjudicators get it wrong from time to time. Also, in Ascon Contractors versus Alfred McAlpine Construction, it was confirmed that, unsurprisingly, wholly theoretical calculations will be unlikely to succeed. And the final word on this, and final word for today, is in Skanska Construction versus Egger Limited. Judge Wilcox observed that the sophisticated impact analysis of an expert was only as good as the data put in. And I think that's a nice way to finish off, is that whatever method of analysis you use, it's only as good as the information that's available, and the records that are available that have been submitted during the course of the project. I mean, that's what's going to give you the best chance of success here. If you're wondering what I can do to be proactive about managing my program and applying for extensions of time throughout the contract, that's the key. Your records, because again, it's only as good as any program or any method of delay analysis, as Justice Wilcox says, is only as good as the data that's put into it. So look, that's it. I'm going to wrap up there. So we've discussed the contract as a starting point. We looked at the extension of time provisions, and we looked at the various methods of proving delay also. So I'm going to hand you back to Julie, and we'll take some questions.
Okay, thank you, Conor. And there are a fair few questions this morning. First one, will an extension of time in JCT contracts only be granted if both a relevant event has been proved, but also an impact on the critical path? What happens if a relevant event is present, affecting the contractor, but it hasn't affected the critical path?
Okay, sorry, I'm just reading the question again, Julie, because there's a few bits to that.
There's a few sort of relating to relevant events and relevant matters.
Okay, yeah, I mean, only be granted if both a relevant event has been proven, but also an impact on the critical path. Yeah, I mean, that you need the relevant event in order to show that the event that has happened is a risk for which the employer is responsible for. But I mean, the relevant event, must, I can't think of a circumstance where you'll be entitled to an extension of time if it's not on the critical path, Julie. It needs to be on the critical path, because it needs to. What you're doing is that you're asking for, you're saying that there's going to be a new overall completion date. And obviously, and in that you're saying that because you need an new overall completion date, because the critical path has been delayed effectively. That's the thing. If it's non-critical, it's not going to turn up as a delay to the overall completion date. What happens if a relevant event is present affecting the contractor but hasn't affected the critical path? That happens, very, very often. You can still submit a notice and you're given warning that it may become critical, but you know, for now, you don't need to have a new overall completion date. So yeah, it's really to focus on what has actually delayed your critical path. Okay.
Okay. So are relevant events and relevant matters treated completely separately, or do they support one another?
I'd say they're treated completely separately, really. I mean, there's obviously a crossover, but I mean, your relevant events, that's your extension of time provisions in your contract, and basically that's in. I'm thinking of a JCT contract here. That's section 2. You're talking about time. You're talking about progress. Relevant matters then relate to money, obviously, and loss and expense. Sometimes there's a crossover. For example, on that catch-all clause that we discussed earlier, any impediment, prevention, or default by the employer. I mean, that just so happens that it's a relevant event, but it's also a relevant matter. So in that case, it supports each other. But the submissions are pretty much separate submissions also. One being a submission for the time, the second being a submission for the money. If you have a relevant event, you should submit your notice of that, but don't always assume that will turn up as a relevant matter also, because that's not always the case. You need to go and check your contract to see, well, what are the grounds for which I'm entitled to the loss and expense as a result of a relevant matter under my contract.
Okay. Another question here. Under the contract, a prerequisite of practical completion is to issue the ancient health and safety file. In the instance that the contractor has failed to issue the health and safety file at practical completion, would it be good practice to issue an extension of time to realign the completion date and practical completion?
I mean, as an employer there, I wouldn't be issuing any extension of time, because that's an obligation on the contractor to submit his health and safety file on time. So, I mean, the extension of time is, you know, that relates to events for which the employer is responsible. If the contractor has failed to give his health and safety file on time, then I don't see how he'd be entitled to an extension of time as a result. I mean, for admin, you could note the delay, but as an employer, I'd be saying, we're not granting practical completion until we receive the health and safety file. That usually cuts out any more discussion around it, and the contractor goes away and sorts out the health and safety file.
Okay.
So that's the best advice I could offer there. Okay.
Understood. Okay. Someone else is saying, presumably this weather would not be a relevant event on the basis that it is known as the Beast from the East 2, i.e. a sequel to the one 2 years ago. Would the first Beast from the East have been a relevant event, or was that just Snow 2, as we do get it if irregularly? It's a fair point.
Yeah, good question. Beast from the East 2. Yeah, I mean, you got to really go back and look at. You got to go into the you know, the weather records. I mean, did the Beast? I can't remember. Did the Beast from the East 1 happen in February 2 years ago? You see, I can't remember. What you got to do is analyze when that happened, but you also got to look at, you know, the level of snowfall. How long were temperatures below freezing? I mean, given the recent cold weather, it's become very difficult, if not impossible, for most sites to pour concrete, because you can't pour concrete in temperatures that are consistently below, I think it's minus 3 or 4 degrees, because the concrete simply won't cure. So again, there's no real, that's again, what I'm trying to encourage you to do is to get it stuck into the detail here, because even people at the moment, I mean, it's snowing where Julie is at the moment, but it's not snowing where I am here in London. So we've all been impacted differently, and it comes down to what you can prove to show the lack of production as a result of the exceptionally adverse weather here. So again, you really got to grapple with the detail on that one, Ben, and work it out. Look, pop me an email if you have any more questions on it, but it's really delving into the detail in relation to where your site is and how it has been affected.
Okay, I think that also shows that I should possibly move. Right, another question here. Can unliquidated damages be applied if lags are stated in the contract? Okay,
the short answer to that is no. Your damages are either liquidated or unliquidated. You can't have liquidated damages plus general damages on top. But that's the general position. Again, right. That's the standard position. So be vigilant of it because it's been liquidated. That is generally the maximum amount which the employer is entitled to deduct. Okay.
Okay. Delays to material delivery of imported material are being caused in part by additional customs clearance requirements. This is a change in the law. However, delays are also caused by port congestion. So the relevant event is a change in the law or force majeure.
Yeah, good question. Again, I think you got to look at the detail really to try and establish, you know, were these materials delayed even before the, you know, before the additional customs clearance came in on the 1st of January of this year? You know, was it a case that it was just being caused, you know, as a result of the congestion, which is almost like an indirect effect of COVID-19, you know, before the 1st of January? So it's a change in the law. Again, I think you really got to, you know, grapple with the detail on this one. It does come down to the real specifics involved. You're looking at the right relevant events which to seek your extension of time, but I think you've really got to explain and clarify how much of the delay you think is down to the change in the law and how much you think that the delay is down to COVID-19. Okay.
Okay.
Julie's got a phone call.
Sorry, that's a switchboard going, which has obviously come through to me this morning. Great. Okay, the default position for current extension of time claims is often being presented in regard to COVID as a catch-all for events, which could otherwise be argued as subcontractor or supplier delays. Does COVID trump supply chain in these times, or can a claim for COVID be evaluated by the employer as a contractor supply chain delay?
Yeah, again, I mean, that's so the contractor is experiencing, I guess, supplier subcontractor delay. Does COVID trump the supply chain in these times, or kind of claim? I mean, a contractor will have, you know, a separate contract with a subcontractor and a separate contract with his suppliers. Unless you're considering suppliers to the subcontractor, but in such circumstances, you know, the responsibility there is on the subcontractor. You know, if the subcontractor has subcontracted to provide such materials, well, then that, you know, that's what his contract requires him to do. As to whether he's entitled to a delay, it'll depend again on the relevant events or other grounds for which the subcontractor may be entitled to his extension of time. Presented in regard to COVID as a catch-all. I mean, again, like I've been saying, is that it is really, you know, based on, you got to get into the specifics of what's going on, and, you know, has the subcontractor shown a cause and effect between COVID and the delays that he's experiencing? There's no, you know, we can only provide, you know, we can provide guidance on the point, but it really does boil down to the specifics in each case. So it's hard to give a kind of a general answer on that one. Okay.
Okay. If there is a delay incurred due to a client issue, but subsequently the contractor catches up time, are there grounds for an extension of time? The contractors in this case is JCT SBC. Yeah,
I mean, if the delay is caused by a client, so the contractor is entitled to his extension of time, but he subsequently catches up time. I mean, arguably then there's, no extension of time is required because the overall completion date has not been delayed. I mean, if the overall completion date remains the same, then you don't need an extension of time because one, the employer can't deduct LADs because he still hit the same completion date. And the contractor, he's caught up his time. Now, what the contractor may want to do is that he'll have to consider, I mean, if he's accelerated the project, he shouldn't have done that without an instruction. So a contractor catching up time, I mean, if he accelerates, he'd want to have that pre-agreed with the employer before carrying out such acceleration. And that really is a discussion to be had at the time when the delays occurred, because what the contractor doesn't want to do is to go ahead and accelerate and then apply for the additional costs afterwards, because there's no requirement on the employer to pay those in the event that the acceleration was carried out without agreement with the employer. But to go back to your question, is there grounds for an extension of time? No, because the overall completion date doesn't need to be extended. That's the key thing.
Short and sweet.
Yeah.
Someone else is saying here, you say must be on the critical path. Does that mean including or excluding contractors float?
I knew this would come up because everyone wants to know about the float. Even when I mentioned it, I knew there'd be questions on it. You say it must be on the critical path. Well, the reality is that if activities are not on the critical path to begin with, and they are effectively floating, if those events are delayed for long enough, they will become critical. So, for example, I'm trying to think of an example at the moment. Yeah, if you have an event like I'm looking at a delay analysis at the moment, and basically the brickwork wasn't on the critical path because it was a steel frame with a steel with basically like a Metsec sections, and internally we had a framing system that didn't require the brickwork to be on the critical path. It took it off the critical path. But what happened was there was such delays to the brickwork that it did become critical, because all the while we were carrying out the brickwork, we couldn't strike the scaffolding. Now that's a perfect example of an event that wasn't originally on the critical path, but because there was such delays to the brickwork, we couldn't strike the scaffolding, and the scaffolding was required to be removed, obviously, in order to complete the project. So, there you have an example of a non-critical event becoming critical. And don't ask me about who owns the float. That's a completely separate webinar for another day. Okay.
Yes, that's definitely going to be in your QS series at some point, I feel.
Absolutely.
Okay. With regards to mitigating delay, is there an obligation that the contractor must commit to spend their money in attempting to mitigate? And what happens if, after spending additional money, none of the delay is mitigated?
Yeah, good question. This comes down to the I suppose the obligation to mitigate and the endeavors. I mean, there's like a hierarchy of endeavors that we use. I mean, if the contractor, for example, is required to use reasonable endeavors, that generally means that he doesn't have to spend any more money in trying to mitigate the delay. He has to show that he is being reasonable, but he doesn't have to incur additional costs as a result. But think about a best endeavors obligation. That is a higher obligation on a contractor. And if there is a best endeavors obligation involved, then if the contractor is required to spend smaller, reasonable amounts, because of the best endeavors obligation, it could be found that he won't be entitled to recover those reasonable amounts as a result of his best endeavors obligation. So you can see, very important to understand what your obligations are under the contract, because if it's a reasonable endeavors, generally no money. But if it's a best endeavors, that's a higher obligation, and that can result in more cost, which potentially is not recoverable. So just be aware of that. Watch out for what the endeavor is required, or what the obligation is under your mitigation clause in the contract.
Okay. Have we got time for one more question?
Yeah, we do.
Okay. With the current pandemic, how successful have claims been for an extension of time due to COVID-19?
Yeah, look, very good question. We did a COVID-19 webinar. I think it's available on the website, Julie, before, and we talked about this in a lot of detail. How successful have claims been for an extension of time? I think there has been a general acceptance, and look, I see, in the larger scheme of things, I see I don't see that many, but the few I see is that force majeure has been widely accepted as a relevant event for circumstances associated with COVID-19, and I think that's been quite sensible because force majeure, it's an event outside of the control of either of the parties. I mean, neither of the parties obviously have any control over COVID-19 or where it came from or what it's doing. So I think, based on the relationship, I think it's put a lot of strain on relationships, but I think there's been a wide acknowledgement that what is the point in the employer coming down, overly harsh on a contractor, due to COVID-19. I mean, because that's going to ruin the relationship, and it's inevitably going to end up in a dispute. And I think a lot of employers have taken a more practical approach to basically trying to ensure the contractor is doing the best he can. Excuse me. He's doing the best he can. He's trying to resource the project as best he can. He's whilst also adhering to, it's difficult for contractors. They're trying to deal with the new site operating procedures introduced by the CLC, trying to get people working at, whilst being socially distanced, trying to make sure their, hygiene is as good as it can be, so it's difficult. So my experience has been that employers have been sensible with the contractors about COVID-19 and the delays. I hope that continues to be the case, because if it isn't, it'll be a difficult time for a lot of parties. And COVID-19, nobody can control what's going on. So I think if your contractor is doing it as much as he can, he's using his reasonable endeavors to progress, I think that's as much as you can ask for now. Okay.
Now I'm aware we have got time constraints and we have overrun, but we do still have a fair few questions left. Conor, I'm sure you're happy to undertake that we will answer those questions and pop something up on the website for the questions we haven't yet got to.
Definitely, because look, it's prompted, there's prompted a lot of questions here. So definitely, Julie, we'll follow up with the answers to any of the remaining questions. And look, if any of you want to email me directly, you have my email as well. So I think we'll have to leave it there for now. Okay,
that's perfect. Thank you very much, Conor. That was obviously a well-received seminar there with all the questions and lots of thank yous coming in. So thank you for your time. Thank you everyone for joining us. We do have another seminar tomorrow night where Mohammed Huck is continuing with his Adjudication Matters series and talking about responding to a claim. If you'd like a place or like to log in for that, please do email us seminars@silverllp.com. Otherwise, we will see you all again soon, I'm sure. So thank you everyone for your time. Thank you, Conor. And
thank you, Julie.
Stay safe, everyone.
Thanks, everyone. Have a good day. Thank you.